Folk wisdom tells us that if it looks like a duck and quacks like a duck, it's probably a duck. If a statute imposes a monetary fine for doing a thing, is that a criminal statute, even if Congress calls it a civil penalty? The United States Supreme Court considered that question in United States v. Ward. Section 311b(3) of the Federal Water Pollution Control Act prohibits discharging oil or other hazardous substances into navigable waterways. Subsection 5 requires facility operators to report any discharge to the appropriate agency. Failure to report is punishable by a fine and imprisonment of up to a year. Subsection 5 also provides for use immunity, meaning that information reported as required can't be used against the reporting party in any criminal case, except in a perjury prosecution for giving a false statement. Subsection 6 imposes a civil penalty of up to $5,000 on violators based on the violator's culpability and the size of the violator's business. Oil escaped from an Oklahoma drilling facility retention pond into Boggy Creek, a tributary of the Arkansas River. L.O. Ward, the premises leasee, reported the discharge to the Environmental Protection Agency, who then forwarded the matter to the Coast Guard, the responsible agency. The Coast Guard assessed a $500 civil penalty against Ward. Ward's administrative appeal was denied. Ward then sued various agencies, seeking to enjoin collection of the civil penalty. The government sued to collect the penalty, and the district court consolidated the cases. The district court ruled that the government's use of Ward's discharge report to impose a civil penalty didn't violate his right against self-incrimination. The court affirmed the civil penalty, but reduced it to $250. The 10th Circuit reversed, holding that the civil penalty was sufficiently punitive to invoke the right against self-incrimination. The Supreme Court then granted cert.